Let's pick up on our first story. Now, the Senzo Meyiwa murder trial, the trial as a whole, is set to only resume in about September this year. But today, the High Court in Pretoria has been dealing with an application that was brought forward by Advocate Malesela Teffo, who wants accused 1, 2, 3, and 4. Those are his clients. He wants the charges against them dropped. You'll recall these are the men, along with another accused, represented by Advocate Mshololo, who the state believes murdered Senzo Meyiwa in 2014 in Vosloorus. They say it was a robbery, but Teffo says these men have clearly done nothing wrong. Now, in just the last 2 hours or so, Advocate Teffo said that accused number 3 is being abused, tortured possibly, at the Kgoshi Mampuru Correctional Center in Pretoria. And we're expecting the court to resume at 2 o'clock and deal with the issue of the reading of a letter written by the accused, which would then shed light on the nature of the abuse. Let's talk about what's been happening in court today with legal expert Nthabiseng Dubazana. A very good afternoon to you, Nthabiseng. Welcome to the program. So we'll talk about the letter in a moment, but I'd like us to begin with putting what's happening today in context, because the actual trial, correct me if I'm wrong, is what we're only going to see begin in September. What's happening today is separate from that, but still related.
That is very true. So today, one of the issues, if not the main issue that was supposed to be dealt with, was the issue of jurisdiction. So when Advocate Teffo Malesela had made his application, he was saying, 1, based on the new docket that was brought to light, and 2, based on the letters that were between the 2 different DPPs, one in Johannesburg and one in Pretoria, wherein he's saying that this court that is currently hearing this matter lacks jurisdiction. That was supposed to be canvassed. Remember, what was ordered by the court was that all parties were to submit heads of argument, but Advocate Mshololo and Advocate Baloi were to only respond to Advocate Teffo's heads of argument, and then all of those to be presented to the presiding officer, who would then make a determination based on such documentation. But none of that was done, and when this the matter commenced today, Advocate Baloi stood up to say that it seems that the issue of jurisdiction is now being abandoned, which then would mean that it means Advocate Teffo's application for his clients to be found, rather be acquitted of the charges, and also now falls away. Now, instead of answering that debacle when he was asked why he did not file his heads of argument so that his opponents can do the same, he then embarked on this new journey, which is now the one of the letter that you said we'll go to later. So in essence, today we are, for whatever reason, dealing with entangled matters when we're supposed to, per the request, Advocate Mshololo, wherein she asked, can we deal with the issue of the heads and jurisdiction first? Let us close that. We have enough time to deal with the other issue that Advocate Teffo wants to bring forth, which is that of the letter. So right now, the issue of jurisdiction is parked, but we're still trying to deal with the issue of the letter as well.
And the issue of the letter is important because Advocate Teffo basically told the court that it's a life and death situation, and that was a point that even Judge Chifuya Maumela was saying is precisely why we need a resolution as soon as today.
That is very correct. But however, in the manner in which he is approaching this, that is also the problem, which is what has been the theme of this case, that procedure hasn't been followed. It is pretty evident that at minimum, he received this letter yesterday. So at minimum, when he received that letter, he ought to have scanned and sent it to his 2 opponents so that by the time he raises this today, they would have had sight of the letter. And then, over and above that, send it to the head of correctional services at Kgoshi Mampuru so they are aware that he is going to be dealing with this matter today in court. That way, all parties concerned can be present in court, and the ones that need to answer to anything are also present, which is the Kgoshi Mampuru officials. The other opponents, which is Advocate Mshololo and Advocate Baloi, don't really have to respond to anything because it's a concern that's being raised by the attorney of accused number 3, which is legitimate and has to be addressed. But let's follow procedure in order for things to be done properly so that your concerns can actually be raised. Adhered to. I think that's why the Maumela asked, what do you mean that after the letter has been read into record, you do not want the court to act on anything? And then his response was either half yes and a half no, but the main reason that anybody would bring such an application to court is for the court to make a pronouncement on what has been raised, whether or not the accused should be moved from this prison to another for safety purposes.
How muddy then? I mean, the rest of us watching on, as people who didn't go to law school, just trying to follow because of just the national interest in the trial of these men accused of killing Senzo Meyiwa, Bafana captain, at the peak of his career, in his prime. How muddy are the waters at this point in terms of figuring out whether we're coming or going in this case, because months later, very little progress has actually been made?
I think they're quite murky. I don't know if we are going to get a proper answer come 2 o'clock when we come back, because the last word that the judge said was that, can you guys come to an agreement on how we're going to deal with this issue? But if we go through the theme of the entire trial, there's been too many aspects that are brought in that are related to the case but are not dealing with the facts of the matter. And as a result, trying to get ourselves out of this trend of having to, we're busy with cross-examination, and then all of a sudden we're detouring and going somewhere else. That's going to be the issue, and that is what the judge keeps raising more often than not with Advocate Teffo, saying, sir, but you need to follow process if you want to deal with certain matters. I think it would have been prudent that he allowed Advocate Mtshali to finish with her cross-examination, so we know at least one witness is done and dusted with, so that all these other things that we're dealing with are not interrupting anything pertaining to the actual facts of the case itself.
And what are the obligations then of the court to the accused, given that we're now hearing that this is a man who is being abused allegedly while in detention at Hoshimamburu Correctional Center? Is it as easy as just moving him to another facility?
Usually it is quite that easy. It usually ends up that way, as long as the allegations can be proven to be true, of course. So like he said when we were about to adjourn, is that there's been instances wherein inmates have lied about such things happening to them. And there's also been instances where inmates have actually gone through such torture, abuse, or whatever the case may be. So it is necessary and prudent that the court pronounces on it once he has heard both sides, which is Advocate Teffo's side and also the Correctional Services side, so they can see how best to protect the life of the accused.
Nthabiseng Dubazana, good to have your time. Thank you as always.